Hello everyone, welcome to MAYANK LAWHOLIC. Today we are solving the DGS HJS paper of 2015. We have already solved the two papers of HJS examination of Delhi Judiciary. Please look into those paper in the respective playlist. Now let's get started. Question number 1. It was an agreement between the parties that no interest will be paid on the amount payable to contractor under the contract. Disputes and differences between the parties in accordance with the arbitration clause in the contract were referred to the arbitration under the Arbitration Conciliation Act 1996. The arbitral tribunal finds amounts to be due to the contractor and makes an award the said amount together with an interest at 24% per annum for the date of entering upon refers till the date of the award. The award to the extent of awarding such interest is liable to be set aside under section 34 of the said act, is not liable to be interfered with under section 34, is liable to be interfered to the extent of the rate of interest. Correct answer in this question is option 1. Is liable to be set aside under section 34 of the act. Section 34 of the Arbitration Conciliation Act 1996 talks about the application for setting aside of arbitral award. Now let us see the question number 2. The liability of the individual co-partner in a decree against a Hindu undivided family carrying business is to the extent of their share in the assets of the said joint Hindu family. This is the right answer. Now let us see the question number 3. A is entitled to succeed to an estate on the death of B. B dies. C, having received intelligence of B's death, prevents the intelligence reaching A and thus induces A to sell him the interest of the estate. Options are: the sale is voidable at the option of A, the sale is binding on A, the sale is voidable at the option of C, the sale is voidable at the option of A as well as C. Here the correct answer is option 1, the sale is voidable at the option of A. Now let us see the question number 4. A Hindu on 2nd January 2016 dies intestate, leaving a wife, 2 unmarried daughters and a son of his wife from an earlier marriage. His estate will be inherited equally with the wife, the 2 unmarried daughters and the son of the wife from an earlier marriage, each getting 1/4 share. Option 2, in 3 parts, with the wife and 2 unmarried daughters getting 1/3 share each and the son of the wife from the earlier marriage not getting a share. Option 3, only by the son of the wife from the earlier marriage, with the wife having a right of maintenance and the 2 unmarried daughters having a right of maintenance and married expenses only. Option 4, only by the wife and the son of the wife from an earlier marriage equally with the 2 unmarried daughters having only a right of marriage expenses at the maintenance. In question number 4, the correct answer will be option 2, in 3 parts, with the wife and 2 unmarried daughters getting 1/3 share each and the son of the wife from earlier marriage not getting a share. A mortgager in possession of a mortgaged property is not entitled to make a lease thereof. In the absence of a contract to the contrary, is entitled to make a lease thereof binding on the mortgagee, provided the lease is made in the ordinary course of management of the property at best rent that can be reasonably obtained, does not contain a covenant for renewal and is for a period of less than 3 years. Option 3, can make lease thereof binding on the mortgage on whatsoever terms he desires and for whatever period. Option 4, is entitled to lease out the same only if expressly permitted to do so under the mortgage deed. Option 2 is the correct answer. Now let us see the question number 6. A sale of immovable property without payment of entire sale consideration to the seller is no sale, is void, is valid, and the seller has a charge upon the property in the hands of the buyer for the amount of the sale consideration remaining unpaid and for interest thereon, is a lease, is voidable. Correct answer is option 2, is valid, and the seller has a charge upon the property in the hands of the buyer for the amount of the sale consideration remaining unpaid and for interest thereon. Question number 7. A decree for injunction is not obeyed, is not executable by the detention of the judgment debtor in civil prison or by attachment of his property or by both, and also by directing the act required to be done at the cost of the judgment debtor, is executable by filing a petition under the Contempt of Court Act 1971, is executable by filing a fresh suit. Here the correct answer is option 2, is executable by detention of the judgment debtor in civil prison or by the attachment of his property or by both, and also by directing the act required to be done at the cost of the judgment debtor. Now let us see the question number 8. The period of limitation for filing a suit for the compensation for defamation is 3 years from the date when the defamatory words are published or spoken, is 3 years from the date when the plaintiff learns of defamation, is 1 year from the date when the defamatory words are published or spoken, is 1 year from the date when the plaintiff learns on the defamatory words having been published or spoken. Here correct answer is option 3. Now let us see the question number 9. A decree for restitution of conjugal right is executable by the attachment of property and by detention in civil prison, or by both, by attachment of property, by imprisonment, by granting a decree for divorce. Correct answer is option second, by attachment of property. Contingent agreement to do or not to do anything if an impossible event happens is voidable at the instance of the party who did not know the impossibility of the event, is void only on establishing that the impossibility of the event was known to the parties to the agreement to sell at the time of making the agreement. Option 4 is voidable at the instance of the either party. Correct answer is option first, is void. Contingent agreement to do or not to do anything if an impossible event happens is void. Question number 12. A person dispossessed without his consent from an immovable property otherwise than in due course of law can recover possession thereof, notwithstanding any other title that may be set up in such suit. Options are: if the suit is filed within 3 years from the date of dispossession. Option second, if the suit is filed within 12 years from the date of dispossession. Option third, if the suit is filed within 6 months from the date of dispossession. And option 4, if the suit is filed within 1 year from the date of dispossession. Correct answer is option third, if the suit is filed within 6 months from the date of dispossession. Contract, the performance of which involves a performance of a continuous duty, is not specifically enforceable only if the court cannot supervise such performance. Is specifically enforceable, none of the above. Correct answer is option second, is not specifically enforceable only if the court cannot supervise such performance. Question number 14. The grant of refusal of temporary injunction under order 39 rule 1 and 2 of CPC is governed only by CPC, is governed by CPC as well as by the provisions of SRA, which with respect to injunction is not governed by the provisions of SRA as they are applicable, or grant of permanent injunctions and not to temporary injunctions is governed only by the principles of national justice. Here the correct answer is option second, is governed by the CPC as well as by the provisions of Specific Relief Act 1963 with respect to injunctions. Question number 15. A notification to the Government of India is proved only by examining the concerned officials of the Government of India, only by obtaining a certificate from the press in which the same has been published or publication thereof, by producing before the court the printed copy thereof. Option 4, only by calling the Secretary of Government of India along with the original notification. Here the correct answer is option third, by producing before the court the printed copy thereof. Question number 16. The terms of a contract reduced in the form of a document can be proved only by providing the document itself. This is the correct answer. Question number 17. A money bill under section 109 of the Constitution of India shall not be introduced in the Council of States is the same as any other bill after it has been passed by the House of People shall be transmitted to the Council of State. Its recommendation and House of People may thereupon either accept or reject all or of the recommendations of the Council of State. And option 4, both first and third. Correct answer is option 4. First is also correct, third is also correct answer. Question number 18. The directive principles of state policy enshrined in the Constitution of India are enforceable by the courts, are not enforceable by the courts, are enforceable only by the high courts, are enforceable only by the Supreme Court. Correct answer is option second, are not enforceable by the courts. Question number 19. The Election Commission of India has been constituted by the Parliamentary Act, is a society registered in the Societies Registration Act, and is an autonomous body of under Government of India, has been established by the Constitution of India, is a part of government thereof. Correct answer is option third, has been established by the Constitution of India. Question number 20. The power of High Court under Article 226 of the Constitution of India extends all over the territory, extends throughout the territory in relation to which it exercises jurisdiction, extends throughout the territory in relation to which it exercises jurisdiction, and to the National Capital Territory of Delhi. And option 4, extend only to the city in which it is situated. Correct answer is option second, extend throughout the territory in relation to which exercises jurisdiction. An arbitration agreement is necessarily required to be in writing, may be oral, may be contained either in documents signed by the parties or in communication exchanged by the parties or by way of an admission. Both first and third option. Correct answer is option 4, both first option and third option is right. Question number 22. While a Hindu wife is an heir of her husband in the event of intestate, a Hindu husband is an heir of his wife in the event of intestate only if there are no sons and daughters, including children of predeceased son and daughter. The statement is true or false? This statement is false. Now let us see the question number 23. A child born of a marriage which is voidable under section 12 of the Hindu Marriage Act 1955, but before passing of a decree declaring its nullity, has a share not only in the properties of his father but will also have a share out of the share of his father in the ancestral properties. The statement is false. Question number 24. Certain amount was due to erstwhile Department of Telecommunication DOT of the central government from the subscriber for providing telephone connection for the year 1992 till its disconnection in the year 1998. In the year 2000, all the assets and liabilities of the DOT were taken over by BSNL, incorporated under the Companies Act, and 100% shares which are owned by the President of India. BSNL filed a suit for the recovery of the said dues from the subscriber, claiming that it is an agency or instrumentality of central government and that the benefit accrued in the favor of DOT of the central government as provided under Article 112 of the Limitation Act would stand extended to BSNL. Whether BSNL is entitled to benefit under Article 112 of the Constitution of India, that is, of a period of limitation of 30 years to institute a suit. Options are yes or no. Correct answer is no. Question number 25. Widows, sons and daughters of a deceased Hindu institute a suit for declaration that the will of the deceased, whereunder the proceeds of the state are to go to a public charitable trust, impleaded as defendant number 5, has been fabricated by the defendant number 1 to 4, brothers of the deceased, and for restraining the defendant from dealing with the estate. The public charitable trust, impleaded as defendant number 5, raises a preliminary objection that the suit against it is not maintainable in view of section 92 of the CPC, and a preliminary issue is framed thereon. Whether the suit against the public charitable trust is not maintainable in view of section 92 of the CPC, correct answer is no, it is not maintainable. Now let us see the question number 26. No court can take cognizance of an offence punishable under chapter 21 of IPC except upon a complaint made by some person aggrieved by the offence, provided without leave of the court, some other person may make a complaint on his or her behalf. Options: if such a person is an idiot or lunatic, if such a person is under the age of 18 years, if such a person is a woman who according to the local customs and manners ought not to compelled to appear in public, and option 4, all of the above. Here the correct answer is option 4, all of the above. Chapter 21 of IPC is related to defamation. Section 499 defines defamation, and section 500 is related to punishment of defamation. Section 501 is related to printing or engraving matter known to be defamatory. Section 502 related to the sale of printed or engraved substance containing defamatory matter. Now let us see the question number 27. X is facing a trial for the murder of an advocate. None of the advocates he wishes to engage to accept in the brief. X thus wants his trial to be transferred from the Sessions Court, the subordinate A, High Court, to the Sessions Court, subordinate to B, High Court. Options: X should file a petition before A, High Court, X should file a petition before B, High Court, and X should file a petition before the Supreme Court, and option 4, any of the above. Correct answer is option 3, X should file a petition before the Supreme Court. Question number 28. In Delhi, offences under section 272 to 276 of IPC are triable by the Court of Sessions only, the Court of Chief Metropolitan Magistrate only, the Court of Magistrate of First Class only, and the Court of any magistrate. Correct answer is option 4, the Court of any magistrate. Section 272 to 276 of IPC comes under the chapter 15 of IPC, that is of offence affecting the public health, safety, convenience, decency and morals. Section 272 is related to adulteration of food or drink intended for sale, and section 273 is related to sale of noxious food or drink, and section 274 is related to adulteration of drinks, and section 275 sale of adulterated drugs, section 276 sale of drug as a different drug or preparation. Now let us see the question number 29. Culpable homicide is not murder if the offender, being a public servant aiding a public service acting for the advertisement of public justice, exceeds the powers given to him by law and cause death by doing an act which he in good faith believes to be lawful and necessary for the due discharge of his duty as such public servant. Option 2, without ill will towards the person whose death is caused. Option 3, both first and second, and option 4, either 1 or 2. Correct answer is option 3, both 1 and 2. Question number 30. An offence, though compoundable with the leave of the court, cannot be compounded under section 320 CRPC if the person who would be competent to compound it is dead, if the person who would otherwise be competent to compound is under the age of 18 years or an idiot or lunatic, and option 3, if the accused is by reason of previous conviction liable to enhanced punishment, and option 4, all of the above. Here the correct answer is option 3, if the accused is by reason of a previous conviction liable to enhanced punishment. Section 320 CRPC talks about the compounding of offence. Now let us see the question number 31. In which of the following decisions Supreme Court pronounced that a victim must seek legal appeal against an order passed by the court acquitting the accused under proviso through section 372 CRPC? Options are Satyapal Singh versus State of Madhya Pradesh, S. Sundaram Pillai versus V.R. Pattabirman, and option 3, Dwarka Prasad versus Dwarka Das Sarraf 1976, and option 4, none of the above. Here the correct answer is option 1, Satyapal Singh versus State of Madhya Pradesh, GAT 2015, SC 281. Section 372 of CRPC talks about that no appeal to lie unless otherwise provided. No appeal shall lie from any judgment or order of a criminal court except as provided for by this code or any other law for the time being in force. Now let us see the question number 32. Under the Code of Criminal Procedure 1973, pre-charge of evidence is recorded in all private complaints, all complaint cases, case instituted on police report, warrant case instituted otherwise than on a police report. Here the correct answer is option 4, warrant cases instituted otherwise than on police report. Question number 33. Statement under section 164 CRPC 1973 can be recorded before Deputy Commissioner of the Police, Station House Officer, any metropolitan magistrate or judicial magistrate, none of the above. Correct answer is option 3rd, any metropolitan magistrate or judicial magistrate. Section 164 CRPC is related to recording of confession of statements. Question number 34. Statement under section 313 CRPC can be recorded only in appeals at any stage without previously warning the accused when the court considers it necessary after the prosecution witness have examined, and option 4 under 2nd and 3rd. Here the correct answer is option 4 under 2nd and 3rd. Section 313 of CRPC is related to the power to examine accused. Question number 35. When a court of session passed a sentence of death, the accused is immediately hanged. The proceedings are sent to Supreme Court for confirmation. The proceedings are sent to High Court for confirmation. None of the above. Correct answer is option 3rd. The proceedings are sent to High Court for confirmation. Question number 36. When a metropolitan magistrate passes a sentence of imprisonment for 3 months, the appeal shall lie before. In the case of 3 months, there will be no appeal. So the option 4 is correct, nowhere. Grievous hurt is defined in under section 320 IPC include dislocation of tooth, fracture of a bone, both the above, none of the above. Correct answer is both of the above. Grievous hurts include dislocation of a tooth and fracture of a bone. Now let us see the question number 38. The offense of attempting to commit suicide under section 309 IPC is ultra vires the constitution, carries on conviction, minimum sentence of 10 years, triable by court of session, and option 4 none of the above. Correct answer is option 4 none of the above. 39. A dashes B to the ground and fraudulently takes out his money from his pocket without his consent. A has committed which offense? A has committed robbery. A appears as a witness before a judge trying a case who does not believe in his disposition and says that A has perjured himself. A moved by sudden passion by the words of the judge and kills him. Here A has committed an offense. And option 2nd, A has committed murder. And option 3rd, A has committed culpable homicides amounting to murder. And option 4, none of the above. Here A has definitely committed the offense, but this is not the satisfactory answer. That therefore the satisfactory answer is option 2nd, A has committed murder. Question number 41. A fires a gun at a wedding reception leading to the death of one of the guests. Whom did he not intend to hurt? A has committed murder. A did not intend killing the guest and thus has committed no offense. A has committed culpable homicide not amounting to murder. None of the above. Correct answer is option 3rd. A has committed culpable homicide not amounting to murder. Question number 42. Under section 142 subsection 2 of Negotiable Instrument Act 1881 was inserted by the Negotiable Instruments Amendment Act 2015 made effective from 15 June 2015. The holder of a check that has been dishonored when delivered for collection through an account can file complaint only. Option 1st, before the magistrate in whose jurisdiction the drawer of the check resides or carries on business. And option 2nd, before the magistrate in whose jurisdiction the drawee bank is located. And option 3rd, before a magistrate in whose jurisdiction the payee resides and tendered the check for payment. And option 4, before a payment within whose jurisdiction the branch of the bank where the payee or holder in due course as the case may be maintains the account instituted. Correct answer is option 4, before a magistrate within whose jurisdiction the branch of the bank where the payee or holder in due course as the case may be maintained the account is situated. Question number 43. Which of the following statement is correct? A is not liable for prosecution in terms of section 141 of the Negotiable Instrument Act if he is A. nominated as director by virtue of his holding an office for or employment in the central government. Option B. nominated as director by virtue of his holding an office or employment in state government. And option C. nominated as director by virtue of his holding an office or employment in a financial corporation owned or controlled by the central government. And option D. nominated as director by virtue of his holding an office or employment in a financial corporation owned or controlled by the state government. Here the correct answer is option 3rd, A or B or C or D. Section 141 of Negotiable Instrument Act deals with the offence by companies. Now let us see the question number 44. The amount maintained in a check figures in rupees 2,15,000 but in words it stated rupees 2,50,000. Which one of the following consequences ensue? Here the check will be taken to be for rupees 2,50,000. Question number 45. Ramesh, who has an account with a branch of the State Bank of India in Dubai, draws a check on SBI Dubai in favor of Abdullah, a resident of Dubai. The check is signed in Kochi and handed over to Abdullah in Kochi. The check when presented by Abdullah through his bank to the SBI Dubai is dishonored. The remedy available to Abdullah is to proceed against Ramesh in accordance with the law applicable in Dubai as regards dishonor of check, to follow the procedure under section 138 of Negotiable Instrument Act 1881, to approach the Government of India for permission to file a complaint against Ramesh, to proceed against the State Bank of India in the Court of Magistrate in India within whose jurisdiction its head office is located. Correct answer is option 1. To proceed against Ramesh in accordance with the law applicable to Dubai as regards dishonors of check. Question number 46. The number of seats allocated to Delhi in Rajya Sabha in terms of the 4th schedule to the Constitution is 3. Question number 47. When a question arises whether a bill is a money bill or not, the decision of which of the following authorities shall be final? Here the fourth option, the decision of the Speaker of the Lok Sabha will be the final to decide whether a bill is a money bill or not. Now let's see the question number 48. Which of the following is described as an offence in the Constitution of India? Option A. Preventively detaining a person in contravention of Article 22. A citizen of India accepting a title from a foreign state under Article 18. Trafficking in human beings and beggar under Article 21. Enforcement of disability arising out of untouchability Article 17. Here the correct answer is option 4, that is C and D. Trafficking in human beings and beggar under Article 21, enforcement of disability arising out of the untouchability under Article 17. Question number 49. The minimum age for being President of India is option 4, that is 35 years, the correct answer. As of date, in terms of the first schedule to the Constitution, India has, here the options are 26 states, 7 union territories, 27 states, 6 union territories, 29 states and 7 union territories, 30 states and 6 union territories. And the given options, no option is correct, because at present India has 28 states plus 8 union territories. Following 8 union territories are Andaman and Nicobar, Dadra and Nagar Haveli and Daman and Diu, 3rd Jammu and Kashmir, 4th Lakshadweep, 5th Chandigarh, 6th Delhi National Capital Territory region, 7th Ladakh and 8th Puducherry. Therefore total 8 UTs and total 28 states are there in India. The second Chief Justice of India was, correct answer is Justice Patanjali Shastri. Here I want to give some additional information. First CJI of India is Shri HJ Kania. He was CJI from 1950 to 1951, and at present 48th CJI is NV Ramanna. Think Justice Patanjali Shastri, who was the second Chief Justice of India, was from 1951 to 54. Question number 52. The first Chief Justice of Delhi High Court was, here the correct answer is Justice K.S. Hegde. Question number 53. The words socialist secular were inserted into the expression sovereign democratic republic in the preamble of the Constitution of India by the 44th Amendment, 35th Amendment, 42nd Amendment, 23rd Amendment. Correct answer is 42nd Amendment Act. Question number 54. The judges who gave the majority view in the habeas corpus case EDM Jabalpur versus Shivkant Shukla were, correct answer is option 3rd, CJI Ray, Justice Beg, Justice Chandrachud and Justice Bhagwati. Question number 55. In Minreva Mills vs Union of India AR 1980, the Supreme Court by a majority of 4 struck down section 4 and 55 of the Constitution 42nd Amendment 1976. The dissenting judge was 2. Justice P.N. Bhagwati is the correct answer. Question number 56. What is the present sanction strength of the Supreme Court of India? At present, the present sanction strength of Supreme Court of India judges is 33 plus 1 Chief Justice, that is total 34. Question number 57. What is the present total strength of the Lok Sabha? 544 seats, 540 seats, 550 seats and 545 seats. At present, there are total 543 seats in the House, which are made up by the election of up to 543 elected members at maximum. One more additional information that I want to add on here. By 104th Constitutional Amendment Act of 2019, the 2 seats of Anglo-Indian, which was earlier nominated by the President of India, was abolished. Question number 58. The present Chief Election Commissioner, who was appointed as such with the effect of from 19th April 2015 is, this question has no relevancy right now because this question was related from the current affairs, but at present Chief Election Commissioner of India is Shri Sushil Chandra ji. Question number 59. The 11th schedule of the Constitution deals with disqualification on the grounds of defection, matters over which panchayats may entrusted with powers and responsibilities, matters on which the Nagar Mahapalikas may entrusted with powers and responsibilities, administration of the tribal areas in Assam, Meghalaya, Tripura and Mizoram. Here the correct answer is option 2nd, that is matters over which panchayats may be entrusted with powers and responsibilities. Question number 60. The capital of Chhattisgarh is, correct answer is Raipur. President Barack Obama got his degree in law from the Howard Law School. Question number 62. In the trial of the murder of Mahatma Gandhi, which of the following accused was acquitted? Correct answer is option 3rd, that is Vinayak Damodar Savarkar. Question number 63. Which of the following is not a Bharat Ratna awardee? Options are M.G. Ramachandran, Pandit Madan Mohan Malviya, B.R. Ambedkar, and Mahatma Gandhi. Correct answer is Mahatma Gandhi, because Mahatma Gandhi was not given Bharat Ratna and all the other options have been given Bharat Ratna. Question number 64. In the National Films Award for 2014, which of the following won the award for the Best Feature Film? This question is related to current affairs. We have to know the recent status of the National Film Awards. Here the National Film Awards for Best Feature Film right now is Marakkar, Lion of the Arabian Sea. Question number 65. Who has been the youngest captain of the Indian cricket team so far? Correct answer is Mansoor Ali Khan Pataudi. Who is the first Indian scientist to win a Nobel Prize? Correct answer is Sir C.V. Raman in physics. India Gate in New Delhi was erected to commemorate the Indian soldiers who died in. Correct answer is option third, that is the First World War. Question number 68. The founder of Aligarh Muslim University is. Correct answer is Sir Syed Ahmad Khan. Question number 69. In which Indian state Silent Valley is located? Silent Valley is located in Kerala. Kerala Silent Valley National Park is located. Question number 70. Badal Sarkar is a famous personality in the field of theatre. Present world chess champion is. Correct answer is Magnus Carlsen. Question number 72. Gautam Buddha attained enlightenment at. Here the correct answer is Bodh Gaya. Question number 73. The person nominated by the President Obama to fill the vacancy in the United States Supreme Court caused by the death of Justice Antonin Scalia is. Correct answer is option second, that is Judge Merrick Garland. Question number 74. The winner of Nobel Peace Prize for 2015. Here again the question is related to current affairs and we have to know the current development in the national prize. So in 2021 the Nobel Prize winners were Dmitry Maratov and Maria Ressa. Two personalities have been given the Nobel Peace Prize for 2021. Question number 75. The winner of Oscar Award for the Best Actor and Lead Female Role in. This question is also related to current affairs. Oscar 2022, that is 94th Academy Awards. Best Picture was CODA. Best Actor in the category of Best Actor, Will Smith got the Oscar. And Best Actress is Jessica Chastain. And Best Original Song which got the Oscar is No Time to Die. Now let us see the question number 76. Julian Assange, the founder of WikiLeaks, has sought asylum in the Embassy of London of which of these countries? Correct answer is Ecuador. International Women's Day is celebrated every year on, that is 8th March. On 8th March, International Women's Day is celebrated every year. Question number 78. Between the January 2009 and February 2013, Hillary Clinton was the Secretary of State for the USA. The runner-up in the 2015 Wimbledon's men's single was. Correct answer is Roger Federer. 2020, the Wimbledon Championship was cancelled due to COVID-19. 2019, the winner was Novak Djokovic from Serbia. Question number 80. The ace footballer Cristiano Ronaldo plays for which team? The options which are given right now are not correct because Ronaldo now play for the Manchester United and he also captains the Portugal national team of football. Question number 81. The 2016 Olympic Games will be held in. 2016 Olympic Games held in Rio de Janeiro. 2020 Games held in Japan and again the 2022 Winter Olympic Games held in China, and in 2024 Olympics will held in Paris, that is France. Question number 82. Which of the following is not a permanent member of the Security Council of United Nations? Correct answer is Australia. The CEO of Facebook is Mark Zuckerberg. Question number 84. The European Organization for Nuclear Research, also known as CERN, which operates the world's largest particle physics laboratory, is based in Geneva in Switzerland. Question number 85. The Zika virus is spread by the Aedes mosquito. The winner of the 41st Ranji Trophy in February 2016. Correct answer is Mumbai in 2016. But in 2021, Vidarbha was the winner of the Ranji Trophy. Vidarbha won this Ranji Trophy by defeating Saurashtra. The nuclear power plant in Kudankulam in Tamil Nadu has been built in technical collaboration provided by. Correct answer is Russian Federation. Question number 89. Dr. Bhimrao Ambedkar, whose birthday is celebrated on April 14 every year, was awarded his first PhD in economics by University of London in 1923. He was awarded second PhD in 1927 by University of Columbia. Columbia University is the correct answer. Question number 90. The Vice Chairman of Niti Aayog is. Right now the Vice Chairman of Niti Aayog is Dr. Rajiv Kumar. Question number 91. The unexceptionable means. Correct answer is option third, not open to objection. Sanguine means. Correct answer is option 1, optimistic, confident. Which of the following does not describe the underlined word proprietary? Does not describe. Here the correct answer is ownership. Directions from question 94 to 98, fill in the blanks. Question number 94, the witness could dash be doubted. What she was saying was indeed. Correct answer is option first. The witness could hardly be doubted. What she was saying was indeed true. Question number 95, there is no dash infirmity in the order under appeal. The appeal is dash. Correct answer is option 4. There is no legal infirmity in the order under appeal. The appeal is dismissed. Question number 96. The adverse dash of the government's policies was beginning to adversely dash the company's profitability. Correct answer is option 3rd, effect. The adverse effect of the government policies was beginning to adversely affect the company's profitability. Question number 97. Rahul was prepared to dash his colleague Rakesh but later would not accept anyone's dash. Here the correct answer is 3rd. Rahul was prepared to advise his colleague Rakesh but later would not accept anyone's advice. Question number 98. He realized he was dash on her emotional support but he resented being a dash. Correct answer is option 4. He realized he was dependent on her for emotional support but he resented being a dependent. Now let us see the question number 99. Question number 99 to 101. Supply the missing words in these famous quotes. Question number 99. Orders are not like dash wine becoming better as they dash. Justice Krishna Iyer. This quotation was said by Justice Krishna Iyer and we have to tell the missing word. Correct answer is option 2nd, older. That is, order are not like old wine becoming better as they grew older. Justice Krishna Iyer. Intolerance in itself a form of violence and an obstacle for the growth of a true dashed spirit. Mahatma Gandhi. Here the correct answer is option 2nd, democratic spirit. Question number 101. The life of the law has not been logic, it has been dash. Oliver Wendell Holmes Jr. The correct answer is 3rd, that is experience. The life of law has not been logic, it has been experience. Oliver Wendell Holmes Jr. Directions. Question number 102 to questions 102 to 122. Specific context is given against each of these questions. Read the context and choose the appropriate decision or action. Question number 102. A. In or about year 2015 files a suit against his father and 2 brothers, pleading that the grandfather had in the year 1960 purchased the house in which all the parties to the suit was residing and that the grandfather had died in the year 2000, bequeathing the said house to his father and claiming partition to the suit house. Being ancestral property, one of the 2 brothers, A, impleaded as defendant, supports the case of A and the other brother is proceeded against ex parte. The father files an application under Order 7 Rule 11 of CPC for rejection of the plaint, stating that A or his father's sons have no share in the house. Options are: the said application will be allowed and the plaint rejected, the said application will be dismissed with the cost, the decision on the application will be postponed to the time of decision of the suit, and option 4, an issue along with other issues arising in the suit will be framed to the effect whether the plaint is liable to be rejected. Here in question number 102, the correct answer is option 1, that is, the said application will be allowed and the plaint rejected. Question number 103. Plaintiff files a suit under Order 37 of CPC. The court issues ordinary summons for framing charges issues and the said summons along with the copy of the plaint are served on the defendant, and the defendant files a written statement on the date for which summons was issued. The plaintiff, realizing the mistake committed by the court, applies for summons under Order 37 CPC to be issued. Here the options are: the written statement having been filed, the suit will be tried as an ordinary suit, and option 2, the defendant having along with the summons of framing issues received a copy of the plaint showing it to be under Order 37 of CPC and having within the prescribed time not enter appearance, the suit will be decreed. Option 3, the court will correct its mistake by issuing fresh summons under Order 37 of CPC, and option 4, the plaint will be rejected. Here the correct answer for question number 103 is, that is, 3rd option. The court will correct its mistake by issuing fresh summons under Order 37 of CPC. Order 37 of CPC provides for the summary procedure. Question number 104. A files a complaint of offence under Section 138 of Negotiable Instrument Act against B, C and D, arriving that B and D had drawn a check on a joint account with C in favor of A, and which check had been returned dishonored for reasons of insufficiency of fund, and B, C and D, in spite of notice of demand, had not made the payment within the prescribed time. C contends the complaint to be not maintainable against him because though He was a joint account holder with B and D, but as per instructions to bank, checks could be issued with signature of any two of them, and the check in question was not drawn or signed by him. D also contends the complaint to be not maintainable against him because he had served his relationship with B, because he had severed his relationship with B and C, and in pursuance to which the account was opened. Options are: the complaint against C is not maintainable and will be proceed. Options are: the complaint against C is not maintainable and will be proceed against B and D. Option second, contention of both C and D will not be accepted. And option 3, the complaint against D is not maintainable and will proceed against B, C. And option 4, the complaint against all B, C and D is not maintainable. Here the option first is the correct answer. The complaint against C is not maintainable and it will proceed against B and D. Question number 105. A files a suit for ejectment of B from the premises earlier in the tenancy of B under A in Delhi at a rent of rupees 10,000 per month, and after determining the tenancy of B with respect thereto, B defends the suit pleading that A had orally agreed to sell the premises to B for total sale consideration of rupees 60 lakhs, and of which rupees 5 lakh had been paid in cash, and for specific performance of which agreement he, though after the institution of suit for ejectment, but before filing the written statement in the suit for ejectment, he had filed a suit which was pending. B contends that since his entitlement as an agreement purchaser is to be decided in the suit filed by him, the suit for ejectment filed by A should be stayed. Options are: the suit will be so stayed, and option second, the application of B for stay of the suit shall be dismissed, and option third, the trial in the suit will proceed, but the execution of the decree, if any, for the ejectment shall await the judgment in the suit for specific performance, and option 4, the suit for ejectment will be summarily dismissed as premature. Here the correct answer is option second, that is the application of B for stay of suit shall be dismissed. Question number 106. A on 7 January 2014 files a suit for recovery of possession of immovable property and mensne profit from B, contending that he had let out the property to B by a registered lease, deed dated 20 January 2012 for a period of 1 year, and after expiry of the said 1 year also B was allowed to continue as a tenant on the same terms and conditions as contained in the registered lease deed, though without executing a fresh lease deed, and that the tenancy of B has been terminated by a notice dated 11th November 2013 under section 106 of Transfer Property Act 1882. B contends the suit to be not maintainable because the notice of termination of tenancy was of 10 days only instead of 15 days as required by law. The suit remains pending for over 2 years. Options are: the suit will be dismissed because the notice is for 10 days only instead of 15 days as required by law. And option second, institution of suit itself amount to termination of tenancy, and since the suit has remained pending for more than 15 days, the defect in the notice was immaterial. And option third, because of defect in notice, though A will be entitled to decree for possession but not for mense profit. Option 4, the suit on the avertissements made in the plaint and the notice filed as annexure there which should have been rejected at the outside under Order 7 Rule 11 CPC. Correct answer for question number 106 is option second, that is institution of suit itself amounts to termination of tenancy, and since the suit had remained pending for more than 15 days, the defect of the notice was immaterial. This is the right answer. Question number 107. Suit filed by A for recovery of possession of immovable property is defended by B, contending that though he was in adverse possession of immovable property for a period of 5 years only prior to the institution of the suit, but before the said 5 years, C was in adverse possession of the property to the knowledge of A for a period of 20 years, and thus the suit filed after 25 years of first C and then B being in adverse possession of property was barred by time. Options are: B is not entitled to claim the benefit for the period for which C was in adverse possession and the suit is within time, and option second, B is entitled to the benefit of the period of which C was in adverse possession and the suit is barred by time. In question number 107, the option 1 is the correct option, that is B is not entitled to claim the benefit for a period for which C was in adverse possession and the suit is within time. Question number 108. A obtains from the courts at Bombay a decree against B for recovery of money and has the said decree transferred to Delhi for executing against the properties of B at Delhi. However, B dies though after transfer of decree to Delhi, but before service of notice of execution issued on B. Option: the application for substitution of legal heirs of B has to be fulfilled in the courts of Bombay. The application for substitution of legal heirs of B can be filed in the courts at Delhi to which the decree has been transferred. And option third, the application for substitution cannot be filed in either of the courts as the decree because of the death of B has become invalid. And option 4, the application for substitution will have to be filed in the Supreme Court of India. In question number 108, correct option is option second, that is application for substitution of legal heirs of B can be filed in the courts of Delhi to which decree has been transferred. Question number 109. A files a suit under Order 37 of CPC for recovery of money from B, pleading that A given on a loan a sum of rupees 5 lakhs to B via check, which was duly encashed in the account of A, but B had failed to return the said amount received by him by check. Options are: the suit is maintainable under Order 37 of CPC. Option second, the suit is not maintainable under Order 37 of CPC because A has not filed a check which payment was made along with the plaint. Option third, the record of the banks on which the check was issued and in which the check was encashed shall be called if payment is indeed found to be made by check. The suit would entertained under Order 37 of CPC. And option 4, the suit as per the avertment made in plaint is not maintainable under Order 37 of CPC. In question number 109, the correct answer is option 4, that is the suit as per avertment made in the plaint is not maintainable under Order 37 of CPC. Question number 110. A tenant in a premises at Delhi at a rent at excess of rupees 3,500 per month contests the suit by landlord for his ejectment and for maximum profit on the ground that the suit had been prior to the expiry of the terms of the registered lease deed and was premature. The suit entertained and put to trial. During the pendency of the suit, the term of the registered lease deed expired. Options are: at the time of the final decision of the suit will be dismissed as premature having been before the expiry of the term of the registered lease deed. And option second, notwithstanding the suit being premature since the period of lease has expired, suit with decreed or ejectment and for men's profit for a period after the expiry of the term of the registered lease deed. And option third, the suit will be decreed for ejectment as well as for men's profit from the date on which the institution of suit. Correct answer is option second, that is notwithstanding the suit being premature since the period of lease has expired, the suit will decreed for ejectment and for men's profit for the period after the expiry of the term of the registered lease deed. Now let us see the question number 111. One of the conditions laid down in agreement to sell was that sale would subject to the sale being able to settle with its labor and the labor agreeing to the sale. The labor did not agree to the sale. However, certain other terms of the agreement of obtaining the permission under the Urban Land Ceiling and Regulation Act 1976 and of conversion of the property from industrial zone residential use were implemented. The purchaser contended that he waives the term relating consent of labor and therefore the sellers cannot take advantage of the stipulation which the party whose benefit it was made had expressly waived and sues for a specific performance. Options are: the purchaser is entitled to a decree for a specific performance, and option second, the purchaser is not entitled to decree for a specific performance. Here, the purchaser will not be entitled to a decree for a specific performance. Question number 112. A plaintiff during the pendency of suit amended the plaint including a prayer for compensation and on which relief additional court fees was required to be paid. However, neither did the plaintiff pay the additional court fees nor did the court give opportunity to the plaintiff to pay the same. This suit, including for the relief claimed by way of amendment, was decreed. In appeal, the defendant appellate contended that the decree insofar as granting the relief claimed by way of amendment and on which no court fees has been paid was bad. Options are: the appellate court will set aside the decree granting the relief on which no court fees has been paid only on the ground, and option second, the appellate court will grant an opportunity to the respondent plaintiff to make up deficiency in the court fees as the powers of the appellate court are the same as the power of the trial court. Option second is the correct answer. Question number 113. Plaintiff in a suit claims that the dispute subject matter of the suit had been compromised with the defendant. The defendant disputed the compromise. The court conducted an inquiry and opined that a compromise had been legally entered into between the parties and decreed the suit in terms of the compromise pleaded by the plaintiff. The defendant appealed. Options are: the decree being a compromise consent decree, appeal is not maintainable. Option second, since the defendant had contested that any compromise had been arrived at and a trial or inquiry had held favor of plaintiff, the decree could not be said to be consent decree and the appeal is maintainable. Correct option is option second. Now let us see question number 114. A guarantees to B payment of a bill of exchange by C, the acceptor. The bill is dishonored by C. Options are: A is liable only for the amount of the bill, not for any interest and charges which may have become due on it. Option second, A is liable not only for the amount of the bill but also for interest and charges which may have become due on it but after B has failed to recover the same from C. And option third, A is liable not only for the amount of the bill but also for any interest and charges which may have become due on it. And option 4, only C is liable for the amount of the bill and for the interest and charges due on it. in 114, option third is the correct answer. Question number 116. A files a suit for recovery of money from B before the Court of Civil Judge, Delhi. B files an application under Section 8 of the Arbitration Conciliation Act 1996, pleading that the suit is brought on the matter which is subject matter of arbitration agreement. The said application is allowed and the suit is dismissed. A prefers an appeal to the Court of District Judge. Options are: the appeal is liable to be dismissed as not maintainable. This is the right option. And Section 8 of the Arbitration Conciliation Act talks about the power to refer parties to arbitration where there is an arbitration agreement. Now let us see the question number 117. A files a suit in the Court of Civil Judge, Delhi, for recovery of possession of immovable property at Delhi let out to B at a rent of rupees 4,000 per month of the expiry of the term of the registered lease, and for recovery of mense profit. B contests the suit and issues including as to the rate of mense profits are framed. The civil judge decrees the suit for recovery of possession as well as for the recovery of mense profits damage for use and occupation at the rate of rupees 6,000 per month from the date of expiry of lease till the date of delivery of possession. B appeals to the district judge contending that the decree for mense profit is bad, as the civil judge Order 20 Rule 12 of CPC ought to have ordered an inquiry into the mense profits after pronouncing on the entitlement to the relief therefore. Options are: the decree for mense profit is liable to be set aside and the suit remanded for the conducted inquiry. And option second, there is no merit in the contention of B. Here the correct answer is option second, that is, there is no merit in the contention of B. Question number 118. A files a suit in the Court of District Judge, Delhi, for a specific performance of agreement of sale of immovable property and for the permanent injunction restraining the defendant from prosecuting a suit filed in the High Court at Delhi for ejectment and from mense profits. It is the case A that the defendant had let out the property to A at a rent of rupees 50,000 per month via unregistered lease deed. That subsequently the defendant had orally agreed to sell the property to A but had turned dishonest and instead executing the sale deed in favor of A, had terminated the lease and sued for ejectment of A as a tenant. A also seeks interim relief restraining the defendant from prosecuting the High Court suit. Correct answer is option third, that is, plained insofar as for the relief of permanent injunction will be rejected. Question number 119. A files a suit for the recovery of rupees 2 lakh in the Court of District Judge, Delhi when the court of the lowest grade competent to try it within the meaning of the Section 15 of CPC, the Court of Civil Judge, Delhi. However, no objection is taken neither by the court nor by the defendant. In this regard, the suit is decreed. Option A, the decree is a nullity and cannot be executed. Option second, the decree is a nullity but only if appeal is filed against and without the filing the appeal, the defendant in execution of cannot object on the ground of it being nullity. And option third, the defendant having not taken any objection, the decree is valid. This is the right answer, that is option 3. Question number 120. B owes to C a debt guaranteed by A. The debt becomes payable. C does not sue B for a year after the debt has become payable. Correct answer is option second, that is, A is not discharged from his sureties. Question number 121. A and B stand surety for payment of amounts due by C to D. D releases A from his suretyship. Options are: B automatically stands discharged. Option second, B does not stand discharged merely from D releasing A from his suretyship. And option 3, though B does not stand discharged but can separately seek relief against A as a co-surety. Here the correct answer is option 3rd, that is, though B does not stand discharged but can separately seek relief against A as co-surety. Question number 122. A claiming title to an immovable property on the basis of registered agreement to sell, power of attorney and will from the registered title holder in his favor is forcibly dispossessed from the property by B, also claiming title on the basis of registered agreement to sell, power of attorney and will, etc. from the original title holder. A files a suit for declaration that the agreement to sell, power of attorney and will in his favor being prior in the point of time to the agreement to sell, power and attorney and will in favor of B. A has a better title to the property than B. B contends that suit is not maintainable since he is in possession of the property and A has not claimed the relief of possession. A states that his right to recover possession will arise only after declaration sought by him is granted. Here options are: the suit is maintainable, and option second, the suit is not maintainable. Correct answer is the suit is not maintainable. Question number 123. Against an order of dismissal of suit consequent to rejection of plaint, options are: revision petition under section 115 of CPC lies, a petition under article 227 of the Constitution India lies, and option 3, an appeal under article 96 of CPC lies, and option 4, an appeal under order 43 of CPC lies. Correct answer is option 3, that is an appeal under section 96 of CPC lies? Section 96 talks about the appeal from original decree. Question number 124. In an appeal against a decree from recovery of possession of immovable property and for mentioning profits pendent light and future, court fees as to the plaintiff is payable. Court fees besides on the plaintiff also on the mentioned profit decreed is payable. Option 3, no court fees is payable, and option 4, fixed court fees is payable. Here the correct answer is option 2, that is court fees beside as on the plaintiff also on the mentioned profit decreed is payable. Question number 125. A child born of a marriage which has been declared null and void under section 11 of the Hindu Marriage Act 1955 is a legitimate child and has a share in the property of his father, is an illegitimate child and has no share in the property of the father. Option 3, would have been legitimate and had a share in the property if the marriage had not been declared null and void, but since in the case the marriage has been declared to be null and void and has no share. Correct answer is option 1, that is a legitimate child and has a share in the property of father. So that's all. This video we have completed a DGS HJS paper of 2015. It is a humble request, please like, share and subscribe our channel, and also please join our Telegram group, the link of which is given into the description section. Thank you so much. Thank you for watching.